Miss Love and her alleged prosecutorial misconduct was mentioned by Doug Weinstein. All right, and y'all are saying my volume's still low? For real? Oh, God. All right, hold on. So anyway, he brought that up, and a lot of people say, what in the world is going on with that? Miss Love is having an issue with prosecutorial misconduct. Well, check this out, and we're going to see what's going on here. So this is prosecutor misconduct, and here's the number here. And who is it? Who's about to get in trouble? Oh, Lord. Fulton County District Attorney's Office, Adriane Love. Uh-oh. Here we go. So what is going? There's no date provided for the offense. And then what are the offense or offenses in this case? Attorney misconduct. We'll see what that means in a second. Cooperative misconduct, failure to disclose Brady/Giglio material, which we've seen several times before. Reporting authority. This complaint has been forwarded to the State Bar of Georgia. All right. And we've got some supporting documents here we're going to go into. And the person who filed this, what did they say? While Whitaker is allowing the 20-month trial to move forward, she also admonished prosecutors taking the rare step of ordering them to watch a training video on the importance of sharing evidence with the defense attorneys and other professional obligations. All right. So they have a couple of supporting documents here we're going to go into. This first one is from the Atlanta. Hold on a second. Is this the right one? Yeah, Joseph did this one too. Okay, this is the Atlanta Journal. Let me make sure I get this so y'all can see it. And this is talking about some of the issues they had and what actually went down in this situation, just to give you guys a little bit of a refresher. All right. So judge denies mistrial in Young Thug's case, but rebukes prosecutors. Prosecutors instructed to watch training video. So this is going to break everything down. Let's get started here. And if y'all don't follow Joseph Papp over on X, you definitely should. He gives a lot of updates on the YSL trial and does a good job covering everything that's going on because he is actually in the courtroom. All right. The gang and racketeering trial of Atlanta rapper Young Thug and 5 others will continue after Fulton County Superior Court Judge Paige Reese Whitaker denied the last remaining request from the defense attorney seeking mistrial. And we went through those ad nauseum, right, back in the day. While Whitaker is allowing the 20-month trial to move forward, she also admonished prosecutors taking the rare steps of ordering them to watch a training video on the importance of sharing evidence with the defense attorneys and other professional obligations. Several Atlanta attorneys and former prosecutors said Friday that they've never seen a judge mandate a training video and that they would be mortified by such a remedy. Yeah, we were calling for a mistrial too, which is crazy, but we'll see what happens here. I think that's unprecedented in the state of Georgia, said trial and appellate attorney Andrew Fleischman. Hopefully I said that right. Who has closely monitored this case. It is very embarrassing, and it does indicate that the state is just not following its Brady obligations. Brady violations occur when prosecutors fail to turn over evidence that could be helpful to a defendant's case, which we've seen over and over and over and over. Leader of Young Slime Life, which prosecutor alleged is a criminal street gang based in South Atlanta, responsible for drug deals, robberies, and at least 3 killings. Williams' attorneys deny the charges and maintain that YSL is simply the name of the Star record label. The trial has become the longest in Georgia's history. Defense attorneys in this case have complained for nearly 2 years that prosecutors are intentionally withholding discovery evidence required to be turned over before the start of the trial. Whitaker said she will provide the training video for the Prosecuting Attorneys Council of Georgia and that the viewing would occur under her direction. Yeah, right.
Stop the cap.
Y'all think that really happened? I don't. A spokesman for Fulton County District Attorney's Office declined to comment on the judge's ruling. Former DeKalb District Attorney Robert James said, as a prosecutor, the disclosure of Brady material is not something to play with. Brady is one of those things that's sacrosanct, James said, just like Judge Glanville's chambers, right? If you have it, turn it over. It's not that complicated. Former DeKalb DA J. Tom Morgan, who teaches undergraduate students at West Carolina University, said it's ultimately the DA's job to educate their prosecutors about the importance of turning over such material. He said that as a former prosecutor, Whitaker might be a little perturbed and may be trying to ensure that if there is a conviction, it won't be overturned on appeal. We talked about this. She's protecting her reputation. Judge Whitaker, and by she, I mean Judge Whitaker, she has some aspirations she wants to reach. I know a lot of y'all have mentioned that she may be trying to get into the Supreme Court. I haven't found anything verified on that, but she's made it clear that she wants to follow everything to the letter and she wants to see this trial through. So there aren't any issues and it doesn't look bad on her. Excuse me. All right, here we go. Never been truthful. At issue in recent mistrial motions were remarks the state's star witness Kenneth Copeland made during a secret ex parte meeting June 10th with his attorney, then presiding, or the predecessor judge, as Brian Steele likes to call him, the predecessor judge, Earl Glanville, and prosecutors, and about 9 other people. During this meeting, Copeland said, "I have never been truthful a day in my life." He said, "God's honest truth, I'm a liar," according to the transcript. It was information defense attorneys found out about only after seeking Glanville's removal from this case. Whitaker acknowledged that as the prosecution's key witness, Lil Woody's statement would have been helpful to the defense. Which frustrated a lot of us even more, because if that's the case, then this should have been a mistrial just based off of that, right? You just stop right there. If they should have given the information, get rid of the case. Whitaker acknowledged that as the prosecution's key witness, Copeland's statement would have been helpful to the defense, and they should have been in that ex parte meeting, should have been a mistrial, whatever. Copeland may have little credibility. He may speak in hyperbole, Whitaker wrote, but the facts remain that for a defense attorney, this nugget by a key state's witness is gold. Jeez. This amounted to suppression, whether willful or otherwise, of what was objectively Brady impeachment material, Whitaker wrote. She said the lapse was likely inadvertent or part of the state, or on part of the state, and she does not attribute bad faith to anyone on this issue. And we went through, and we're going to review this motion where she said, yeah, okay, they messed up, but I don't think they did it on purpose. How she would know that, I don't know. I mean, can't we just look and see the actions that happen and then move forward and make a decision from there, Judge Whitaker? Why is this trial still going on? I don't know. This does not appear to the court to have been a purposeful violation, Whitaker wrote, but rather a negligent overlooking of the impeachment value of Copeland's in-chamber statement. So it sounds like they just threw Glanville under the bus so there wouldn't be a mistrial to me, honestly. So they're like, yeah, they did something wrong. This was a bad idea. You should have had the defense there so they could ask questions, do what they need to do. So Judge Krause got Glanville off the trial. Let's move forward and not worry about what Hilton and Love did. But the fact that a violation of a defendant's constitutional rights has been averted does not, under these circumstances, provide cause for celebration, she wrote. Instead, she said it is cause for sober reflection and an examination of processes, procedures, and approaches that allowed this to occur. Jeez. Attorney Doug Weinstein, who sought a mistrial on behalf of his client, DeMonte Kendrick, said they were disappointed with Judge Whitaker's ruling. Although Glanville's removal from the case might make it for fair proceedings going forward, Weinstein said it does not remedy the last 19 months of due process violations. And then you remember Bruce Harvey kind of said the same thing, but in a different way. Bruce Harvey filed a motion, basically said, Judge Whitaker, we've got 19 plus months of this trial that you're not going to have context on. You're not going to be able to see what the state was doing, how they were moving throughout this trial, and how things have happened over and over and over. You had Westmoreland standing up and saying, Judge Whitaker, these issues that you're having, we've been dealing with these for over 2 years. Just end this thing. Judge Whitaker said, nah, this is my trial now. We're going to dust things off. We'll clean it up and try and move forward. Oh, man. The damage done by Judge Glanville and the state has infected the entire body of this trial. An emergency amputation of the judge can't save it, Weinstein said. That sounds like something he would say. Judge Glanville was ultimately removed from this case in July after defense attorneys questioned the June 10th ex parte meeting and called for recusal. Weinstein is seeking an order to allow him to immediately appeal Whitaker's ruling. Whitaker also again rejected calls to remove Chief Deputy District Attorney Adriane Love and Deputy DA Simone Hilton from the case, but warned that any further failure to abide by the rules of professional conduct or lack of candor of the court may trigger the extreme sanction or removal of this case.
Stop the cap.
Nobody believes you. Nobody believes you. And shout out to Joseph Pat for writing that amazing article. We also have a couple of these motions that we just referenced and were referenced in that article as well. This was the first one. This is the additional motion to disqualify lawyers Love and Hilton. Of course, this was filed by Brian Steele. Y'all remember we went through this one. I'm not going to go back through that one. And then this is the second page and then the third page. And there was one point in here that I wanted to read. What page is it on? Let me see here. Oh, here we go. Let's go to number 6 here. When the state was attempting to... Let's go back. Lawyer Love's allegations against undersigned counsel to the prior court were proven beyond any doubt to be totally, knowingly false. And then it says, over Mr. Williams' objection, when the state was attempting to introduce a January 26, 2015 social media posting from co-indictee Garlington's account during the testimony of Detective Gaither, Lawyer Love told the prior court that only Mr. Williams' voice could be heard on this video/audio, except for the one voice saying yeah in the background. Undersigned counsel told the prior court, or the predecessor judge, as he likes to put it, that Lawyer Love was incorrect and that several persons' voices were audible on the social media posting. Lawyer Love falsely accused undersigned counsel of misrepresenting facts to the prior court. Of course, Lawyer Love has proven to be the person who was untruthful and was again falsely accusing undersigned counsel of wrongdoing. This pattern of prosecutorial misconduct illustrates the enormity of unethical conduct of Lawyer Love and the state of Georgia in this case. So what do y'all think, if anything's going to happen from this? Because these are some serious accusations. They already tried to go through the proper process, as you see from this motion filed by Jeffrey Williams, aka Brian Steele, that they wanted to get Miss Love out of here, and rightfully so. I mean, there's been so many missteps. Judge Glanville was letting them do whatever they wanted to while he was on the stand, and nothing happened. Judge Whitaker, she seems to be a little bit more, what's the word? She seems to have less patience when it comes to letting Miss Hilton and Love do what they want. And honestly, Miss Hilton hasn't been trying anything. She's been very subdued, but Miss Love, it's going back and forth, has been a big issue. So let me know what y'all think in the comments in the chat, if anything is going to happen from this. And I guess we're waiting to hear from the state bar on whether they're going to hold Miss Love accountable.